First, I want to thank Janet Gongola, Barr, Drew Hirschfield, who's spoken on the phone, and others at the Patent Office here for allowing me to speak on behalf of the Inventor Network of the Capital Area, also known as INCA. INCA is a nonprofit educational organization founded in 1993 with an interest in providing information regarding patents, the innovation process, marketing, licensing, and other endeavors. I myself am a patent practitioner since 1990. Okay, I'll stand over here. Since 1990, and I'm fairly active in a variety of legal organizations, particularly here in the Washington, D.C. area, the Licensing Executive Society, where I'm the Greater Washington, D.C. Chair. I'm also a member of INCA, and the members have asked that I raise their concerns with regard to this rulemaking. These are laudable goals set forth by the administration, and the transparency in litigation and things like that. These are very laudable goals. But generally, the INCA members have grave concerns about the ongoing attacks on our patent system and the U.S. Patent and Trademark Office. In our view, the patent system is under assault from a variety of sectors: lobbyists, biased academics, and pundits, and others with no regard to our founders' intention to promote innovation in our great nation. Certainly, behavior of some litigants in lawsuits and the threat of lawsuits can be inappropriate. But the courts are already equipped to deal with frivolous lawsuits without further legislation of this sort. Nonetheless, there is a frenzy in the air that our patent system has again run amok, and something must be done, so saith Obama. Hence, we are all here today. Even though the USPTO has made an effort to combat the troll situation in this proposed rulemaking, INCA, myself, and many practitioners, patent professionals, consider the proposed rules entirely unnecessary, seriously onerous, and punitive to the innovation process. Based on my own experience and that of others, we think the entire proposal is not tenable and should be scrapped. The reasons for our view are many and manifest. A goal or justification for these rules is that they assist a troll victim, that is, a recipient of an unwarranted or inappropriate cease and desist letter. Even though these recipients are fairly many, perhaps thousands, involving many, perhaps hundreds, or maybe thousands, involving many hundreds of patents, that number is minuscule compared to the millions of active issued patents and the large number, well over 1 million, of pending applications, not to mention the 500,000 plus new applications each year. Any rule, as Herb suggests, must weigh the benefit and the cost and the burden placed on all applicants and all patent holders with the benefits to the small number of aggrieved parties, however vocal. Also, as Herb mentioned, and earlier today, I hosted a lunch with Bernie Knight, former general counsel here at the Patent Office, there are concerns about the statutory authority for this entire rulemaking. The executive actions, however, driving this notice include the need to ensure high-quality patents, and which is, of course, the goal of the USPTO. However, is the new requirement to provide attributable ownership verification relevant to examiners in the examination process? The examiner corps is already burdened with their duties in examination and don't need a distraction with information that could be potentially biased. Another initiative is to provide the public with more information on the competitive environment. Here too, as Herb mentioned, this would seem to demand that companies engaging in competition, the heart of capitalism, must somehow tip their hand, show their cards, their trade secrets somehow. The corporate issues involved with technology transfers, acquisitions, divestitures, licensing, joint developments, and a myriad of other ones do not need further government meddling. Ayn Rand's Atlas Shrugged show the folly of such intervention in the competitive process. Patent ownership in these contexts is hardly relevant to the goal of the Act, the reduction of these cease and desist letters and the assistance to those victims. In patent practice generally, it is relatively easy to determine who is the owner of a patent in almost all instances, except for perhaps some of these few in the troll context. Of course, the laudable goal of reducing abusive patent litigation and frivolous suits is a good one and a necessary one. But it's unclear how to INCA and others how this rulemaking package addresses that rule, that goal. Just because the rule says it's so does not make it so. The final justification for these new rules is the apparent need to level the playing field for innovators. I guess it all depends on who is the innovator. On behalf of INCA and many of my clients who are also innovators, we would like the playing field leveled indeed. With the passage of the AIA, the playing field tilted heavily in favor of large corporations with deep pockets and against the majority of smaller patent holders now faced with expensive post-grant and other challenges to their patents. It is clear, however, that the innovators in this context, who they are. They are the companies receiving the cease and desist letters that are unjustifiable or unwarranted. For the rest, which may perhaps be, my stats show a much smaller percentage than Herb, maybe 0.1%. Herb says 2%, so I'll just assume it's 1% for the purpose of this discussion. For the rest of the innovators, the 99%, this rulemaking package requests that they give up some of their constitutionally granted exclusive rights in leveling the playing field. Again, Ayn Rand has some choice things to say about that. Turning now to the new nomenclature and duties being imposed to implement the new rules. As the slide said, what is an attributable owner? Already we can determine simply if there's an assignment on file. But apparently determining these title holders is not enough. Now for each title holder, you need to further assess all enforcement entities, such as exclusive licensees, who would not be title holders. Okay, but we are not done. For each entity, we will also need to assess and identify with precision all ultimate parent entities. Here, things escalate. A corporation is not an ultimate parent entity because they are not natural persons. You know, perhaps the shareholders are. They are the ultimate owners. Similarly, all partners in a partnership, board of directors in a nonprofit, and we could go on. But we are still not done. Among all of these entities and persons discussed so far, each must also be assessed as a potential divesting entity, whatever that means. Carl Opedal, in his comments to this rulemaking, which are available, goes through great pains to discuss a variety of these corporate scenarios involving the attributable ownership issue. For example, with foreign corporations, stock splits, corporate reshufflings, and a variety of other situations that are normal out there. He assesses the cost of these analyses in the tens or perhaps hundreds of thousands of dollars, not the $100 that the government is assessing. Also, as Herb mentioned, this could impact trade secrets and corporate strategy and a variety of things that are inappropriate. And the notice proposes regular such assessments throughout the life of the patent application and the issued patent. Potentially every 3 months during pendency, and at least at each of the 3 months at the 3 maintenance fee periods, with the serious penalty, that is the constructive or deemed abandonment of the application or patent 3 months after any unreported change in the attributable ownership list, and the other categories as well. There's a silent or retroactive abrogation of the patent. Thus, we think that the entire proposal should be dismissed, and that the proposed $100 assessment is not a real assessment. Indeed, should these rules be implemented with a serious burden and penalty in place, a quite strict liability standard, all patent holders, the 99%, and the troll patent holders, the 1%, could lose their patent for something inadvertently missed years before. All of this uncertainty and potentially huge burden will stifle startups and investment, another casualty of these rules. Talk about shifting the playing field. Litigators in all patent cases would pounce on any discrepancy, any misstatement, for example, missing one shareholder, any shade of gray in determining an attributable owner, an enforcement entity, an ultimate parent entity, a divesting entity, and other information, all in an effort to abrogate the patent at suit. Virtually all patent holders would taste this bitterness. Judges would be swamped with summary judgments and interpretation of these terms. Every stock option, corporate structure change, investor changes, and other ever-shifting facts would be scrutinized. I myself have felt this kind of nonsense with the stream of McKesson cases that came around a few years ago. And I recently had a clear typographical error that was the subject of an entire summary judgment motion. If enacted, these rules, our patent system will die the death of 3 million cuts. Litigants will be forced to employ these tactics under the new rules because it would be malpractice not to. A plague of litigation could ensue, which would create further calls for patent reform. The solution, well, transparency is a reasonable goal, but reasonableness in the overall is also key. The entire raison d'etre for this rule package is to address the advent of trolls, NPEs, PAEs, and other evil actors. Herb stole my thunder and everything. Why don't we just condition the filing of any cease and desist letter with the updating of the attributable ownership? Address the problem at the event horizon, so to speak. Go for the behavior that's at issue and not to the detriment of everyone for the bad behavior of the few. There is no easy way or easy fix to this inappropriate cease and desist letter problem, but the solution is not here. The proposed rulemaking is ill-advised, places an inappropriate and enormous burden to every patent holder and applicant, millions of individuals and companies. Since the problem is during litigation, the solution should be there also. The USPTO should not go there. This rulemaking package is unwarranted, unjustified, and unreasonable. It constitutes a serious punishment to all inventors, all patentees, and all innocent patent litigants. As a practitioner, any error in this process for one of your own clients could constitute grounds for malpractice. Our patent system should not be burdened with a rulemaking package imposing an unrealistic goal. The consequences of this rulemaking are too dire, the costs are too great, and the burden is too much. I want to thank you for allowing me the chance to speak today on behalf of INCA.
Thank you very much, Mr. Van Dyke. At this time, that concludes those who have pre-scheduled to give testimony. And by a show of hands, I'd like to ask the audience whether there are any members who would now like to give unscheduled testimony. If you could please raise your hand. Yes, we have 3 members of the audience who would like to give unscheduled testimony. So what I'd like to do now is to take our 15-minute break. And during the break, those of you who would like to give further testimony, if you could please see me so we can organize ourselves. And then we will return about 3:05 to resume our hearings with additional witness testimony. Thank you very much. We'll be back in 15 minutes.